Welcome. This is the Domain Name Law Show. Pretty serious space to be in, so thank you for being here. We do this every Tuesday, noon Pacific, 3 p.m. Eastern. There's three hosts. My name's Todd Ryan. I'm one of them. The other two, Jeffrey Neuman and David Michaels. I like to check and do a mic check, even though we usually don't have many technical problems here in this space. But let me see, how's it sounding for Jeff? How's everything going today, Jeff?
Sounds great. Did you just honestly said we say we rarely have problems in this room? I kind of think we usually have. Last week I had a problem, but you know, I think it's better than Clubhouse. Looking forward to doing some video ones at some point in the future.
Yeah, I know the audience would appreciate that. And I guess you're right. We do have problems here, but when I'm in other spaces, boy, they just have issues all the time. David Michaels, our other co host. Hey, David, how's everything going with you?
Pretty good. You guys sound just fine.
Great. Like I said, domain name law, pretty serious subject. Boy, pretty serious. It's a civil crime. It's not criminal, but it can be pretty serious. Today there was a room, NameFi. Victor over at NameFi had Brett Lewis as a guest, domain name lawyer. And I only know him from the cases that we've reviewed, like last week, BeachJet. He was the respondent's lawyer and he won on behalf of his client against Textron, who's been filing a lot of cases for anything with beach in it and Lycombe, as Jeffrey knows. But he was also representing a complainant in a case that we reviewed the week before, Value Max, that we said he's Don. I think he did a great job as the complainant's attorney, but Don Osborne transferred it. And today Brett said the reason why is because of those PPC links. And I did ask him, Jeff. I said, "Hey, you talk about it all the time about these registrars, putting up PPC links when someone registers a name and doesn't do anything with it. As soon as you register it, you don't. You might just let it sit there for a little bit. Like I said, big companies take months, sometimes years to develop out names. But soon as we get one as a domain investor and you don't do anything with it and it goes to these registrar generated PPC links, but you're responsible. They want to know that it's your name. How come you're not doing something with it? It's pretty ridiculous. But anyway, Brett said, yeah, he thought it was ridiculous too that uh, a domain owner would be responsible for those links. But he did say that, yeah, you just need to change your DNS and get off those because some panelists do, in fact, hold it against you. But what has happened with that, Jeff? Any evolution there? I mean, that you're noticing with UDRP decisions, or is it still just flat out the responsibility of the domain owner if you have these PPC links that you have nothing to really, you didn't decide on?
Unfortunately, I'm not seeing any real movement. Um, like you said, it's up to the respondent to make the argument. Sometimes they don't even make the argument, which is a surprise to me. But um, yeah, no, and GoDaddy's just keeps doing what it's doing because it makes money doing it. And yeah, I wish I could say something more positive about that, but no, I have not seen it get better.
We're going to follow our outline, but I did want to ask David about the room that we were in earlier. But anybody wants to check out our outline, go to dnlshow.com/outline. You're going to see a beautiful outline. It just shows, here's what we're going to go through today. We're going to talk about yesterday there was the second annual Levine lecture. We're going to talk about what David Bernstein, he was the featured speaker, some topics he touched on. Then we got a couple news articles that we're going to breeze through because we have a featured topic today and we're going to spend just a little bit of time on it, but that's the legalities of registering or acquiring another person's name as a domain name. It comes up a lot. And then we have three cases I think we can get through fairly quickly. But earlier today, so Brett Lewis is a lawyer out of New York who represents complainants, represents respondents in domain disputes, but also has, an IP firm, does a lot of stuff, I guess. We'll talk with you about it, Jeff, after I get with David, because he was in the room earlier today. David, is there anything that Brett touched on you thought was interesting or any comments from that space earlier?
Yeah, actually, so Brett was, um, he made a really important statement, and that is most respondents don't know what arguments to make and what arguments are invalid. And that is a big problem, both with inexperienced lawyers and domain owners alike. Like a lot of people still, are trying to say, well, the mark is not confusingly similar to my domain name because one letter is off. Well, they don't know that that's not a valid argument. Other people might say, well, okay, that one is, um, it has a different word in it. For example, renew wealth is different than renew, and that's just should be like a trademark infringement issue because, um, well, sorry, that's I'm mixing up with what David Bernstein was saying yesterday and what Brett Lewis was saying today. But the point is, a lot of people don't know what arguments are valid and invalid, and depending on which panelist you get, one might say, oh, it's not a valid argument. So we really have a problem here where there's inconsistency. Um, yeah, and these PPC links, I'll give you an example. Parkingspot.live was transferred last week. TPS was the complainant, and they said they have a trademark in the parking spot. And the GoDaddy lander had PPC links on it. So the owner in India lost their domain name for parkingspot.live.
Right, and there were
But Brett
parking
said,
links, of course, that were there. David, I know
yeah,
you
he
wrote a
says avoid parking.
yeah, you wrote a post about many of David Bernstein's points, so we're going to get to that in just a second. But Jeff, have you crossed paths with Brett Lewis, and do you know Brett? And any comments on Brett that you've ever dealt with before?
No, I mean, I not really. I have not. I mean, it's possible we've met in passing, but no, don't know too much about Brett. Though is when he's on a case, he usually does a pretty good job on behalf of his client. So unfortunately, don't know much more than that.
Yeah, I only knew a little bit about, because I see his name in cases with his firm. I guess it was with a different firm, but no, it seemed like a really. I really liked that he was a really laid back lawyer, not real. He certainly wasn't pompous and stuff like some lawyers who, you know, act like they know so much because they're a lawyer and they tell you and it's final. He was like, listen, it's just, a lot of different perspectives, a lot of different types of cases, and really, some valuable conversation. So I liked listening to him today. Yeah, when I first came into the room, I was like, and Brett Lewis, I don't know who the guy is. I looked at some cases. I couldn't find a lot of cases. He's been part of a lot of cases, but when you search UDRP.tools, if you don't put in Lewis and Lynn, or you just put in Brett Lewis, it shows these limited cases. But I immediately saw two that we reviewed here on domain name law. One last week, BeachJet, that he, like I said, won as a respondent, and then the Value Max the week before that he won as a complainant's rep. So, I like that somebody can go on both sides of the volleyball net. Boom, boom, boom. I'm back. All right. So, yesterday, I know all three of us were there. There was a webinar with David Bernstein as the featured speaker. He talked for 50 minutes straight. It was interesting stuff. He almost had me thinking, you know what? I'm on his side. No, I mean, he very, very smart. I'm sure he's thinking if he listens to this, because I'm sure he will, he'll think, I don't care that Todd thinks I'm smart. I liked his bow tie. He really made a lot of good points. I like that he had basically had his ear to the ground, or his ear to the streets of knowing, yeah, so I'm hearing a lot of people are saying if it's not clear cut case of cyber squatting, it should be moved to the courts, and panelists shouldn't make a decision on it. Well, he took the bull by the horns on that one and said several things about why he believed that trademark infringement is part of UDRP, and he gave up several examples. I didn't write them down, but I remember them because I got a memory like a what. And I thought it was interesting. I really liked the points that he made, although there wasn't a lot of counterpoints because the questions were sort of just asked through Zach, and there wasn't really some verbal sparring at all. But David, you made a lot of comments in your some X posts that some of the things you didn't agree with. But tell us something you liked about David Bernstein's presentation, and then tell us some of the counterpoints that you put together.
So David Bernstein likes to play by technicalities. So he said that his transfer rate is only 50%. So yeah, that's something I like. But when you get into the details, there's some kinds of decisions that he's aligned with on the ICA and other ones he's totally not aligned with. I haven't seen any decisions that he denied transfer on that recently. I just can't remember what they are. But when he was talking about um, family watchdog, well, that's just a generic term. And somebody else had registered familywatchdog.com in 2005 and wanted the domain name. And sorry, the domain names was registered by Lester Weiss. This is in 2005. And then the Family Watchdog LLC filed a UDRP in 2008. They had their pre-existing trademark, but that got canceled in the TTAP proceeding because Lester went ahead and filed his own trademark application for familywatchdog.com and got that registered. And yeah, so basically the board canceled the board ended up canceling trademark for Family Watchdog. But the point is, David Bernstein went through it yesterday in details. Like he said, that should not have been that should not have been denied because it's a trademark issue. He didn't like that answer. Well, guess what? Most panelists don't understand trademark issues, and trademark issues are different or decided differently country by country. And most panelists are not in the United States. And even David Bernstein, who likes to register merely descriptive marks and he's good at it. That's why he's notorious, because he's able to get them done after a whole lot of litigation. Family Watchdog was not one of those domain names or trademarks that actually survived a TTAP proceeding. So he might have been able to win that case, but the complainant wasn't able to. So when Zach asked him, well, what's the difference between a similar trademark and a confusingly similar trademark? David Bernstein said, "Oh, they're the same thing. We made a mistake. We shouldn't have added the word confusingly similar because that is a whole bunch of factors that can be addressed in the other sections 2 and 3 of bad faith and legitimate use." No, there's 13 parts to legitimate use and distinctiveness and confusion. That's like the DuPont factors. So the strength of the mark is an important factor, and that's something that Igor Motsny wrote about on LinkedIn. I posted the link in the thread here on this Spaces show today. And if the mark is weak, they better have super strong evidence that it's distinctive. Well, that's the major thing. If they don't have it, too bad, you're going to get denied, especially if it's just a dictionary term. What do you think, Jeff? Did you listen to it yesterday?
Yeah, I was there. Um, you know, there were definitely parts where, well, he's very, as you said, Todd, very technical, right? And very kind of um, professorial, like he'd be like a law school professor or something. But it came across as just being cold, like uh, without sort of any emotion. Like it didn't matter to him. Um, these domain names. I'm trying to put this into words and maybe not doing a great job. But domain names can be things that people own and work with, and um, that they could have their entire businesses on it. It could be extremely meaningful to them, but for him, it's just a technical decision. And if it's just, is it 51% in that 51% that he believes the complainant, then he's going to find for the complainant, no matter how long the website's been or domain name has been used by the respondent. No, regardless of whether it's innocent infringement or not, because to him, you know, if it is trademark infringement, it cannot be a bona fide use, which I technically agree with, but I don't agree with the fact that a panelist can determine that there's infringement, right? So, and separate that from counterfeiting, which he also talked about yesterday. Counterfeiting is on the extreme of trademark infringement, is the ultimate trademark infringement. You're essentially, it's kind of like a mixture between copyright and trademark, where you're basically copying the entire thing and passing it off as the real thing. Right? So you sell a counterfeit movie, or you know, that's very different than generic trademark infringement, especially infringement that may be unintentional. And so he'll say, he'll make a finding in element two that it's not a bona fide use because he thinks it's infringement. And we went over this last week, right? What makes, and David, you said something to this effect too. What makes him qualified to determine infringement based on uh, the paper, based on very limited evidence, the inability to cross-examine, no experts, to independent experts, to basically testify that it's confusingly similar to the ordinary consumer, right? And so if it's a close call on trademark infringement, I disagree with him. I do not believe that that's a case that should be decided by the panelist if it's a close call. Um, but we take a very different view. Um, and David, sorry, yeah, David Bernstein will just automatically, he thinks he's been hired to make that decision, and so gosh darn it, he'll make that decision. And even if it's 51-49, he'll find in favor of the complainant. But again, I think what really struck me is the little emphasis he put on the fact that domains are owned by real people for real businesses, and it's like that doesn't matter because in his view, well, you could always file an appeal in a court if you get it ordered to take away. And I that to me kind of rubs me the wrong way. But you know, when he was talking about the obvious cases and when he talked about his rate of denials and things like that, it 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 it's in line. It's better than um a lot of other panelists that we've looked at recently. And then also, I think what's interesting is he loves the WIPO overview. And one of the reasons he loves it is because, and he didn't say this yesterday, but he has helped WIPO with that very first overview. So, of course, he's going to love the overview because he helped create it. Um, anyway, those are just some kind of random thoughts.
Well,
Yeah,
good.
that was the
Go
other
ahead.
thing. Sorry, I want to follow up on one thing you said, Jeff. He said he would order a transfer if the scales of justice moved one way or the other, just 1%, like 51-49% probability. That's not acceptable. And here's the reason why. You get a UDRP complaint, you have 20 days to respond. You don't even know what this thing is. It's the first time you've seen it, or it could have been the third time or the 10th time. It's still, you're not an expert. And 20 days, who are you going to hire in 20 days to defend you against a complaint that where the complainant had all the time in the world to time their complaint, fix it, make sure it's a perfect summary judgment. And, sometimes they are great and sometimes they're full of false statements. And how do you have time to uncover all that and hire the right
Right.
person? And that is the biggest problem.
And I think about some recent cases, and I see Karen's on this as well. There are some cases where, again, you kind of have to personalize it a little bit, and it may be in your mind that there's trademark infringement, but that's not a reason necessarily to automatically find in favor of the complainant. And I think of the Lycoming case. I think of Karen's case from last week or 2 weeks ago, where you had a real business owner that's been using a site, and even if it's infringement, that's not necessarily a reason to take it away under the UDRP. And even courts may not take away their domain, even if they found infringement. They may order penalties, or they may order, royalty payments, but they're not going to necessarily say you lose your asset because your trademark infringement. Whereas under the UDRP, losing a UDRP means well, respondent losing a UDRP means that they're going to lose their domain name. And, a whole bunch of reasons why. And I'm trying to gather my thoughts to kind of write something up about why, infringement is not enough to basically prevail under a UDRP.
And you're right about that. And one of the things that judges typically do is make the defendant write a curative statement or something like that. Like, for example, on their website could be, that they're a dealer of that product, but they're not authorized, so they're unauthorized dealer of Lexus vehicles, for example. These are the kinds of curative statements that they can do, and they don't lose their domain names. And Lexus was one of those cases in the Ninth Circuit. But there are been cases before that too. So before the internet, they always said, "Oh, you have to adjust your telephone white directory list string to say agent of whatever." It's like, okay, well, I'll fix that.
Well, what we're speaking on now is the webinar that David Bernstein was a featured speaker at yesterday. It was the Levine annual lecture. And right, Jeff, I agree with you that it was almost matter of fact. I mean, I wouldn't say it was cold. I liked the presentation because he hit on a lot of things. I knew it would hit a nerve with a lot of, say, domain lawyers, or at least would think, I don't necessarily agree with all of that. Now, when he brought up the counterfeiting stuff, I agree with you. Counterfeiting includes, that's inclusive of impersonating, and now you're using the problem. I mean, that's like, those are the obvious cases. So when someone's counterfeiting a product and then it's really counterfeiting the mark, that's way over there. That's like, yeah, that's, certainly infringing. And it was, I'm going to invite Karen up here in a second, and maybe she's available. But because we spoke about her case last week, the AtlanticBeach.com case, and what was important about that was, yeah, somebody's running a business for several years. When do you just decide, especially in a UDRP hearing, okay, just to remove it right out from underneath them, when you know they would have some defenses in a court, okay? And that doesn't mean that, like she brought up, latches is not a defense in the UDRP, but it could have been a defense in court. So do you just append, I mean, basically, take away someone's whole business? But I really appreciate, Karen, you jumping up here on stage. We talked about your case last week. Did you happen to, were you present yesterday when David Bernstein gave his presentation?
Yeah, and there's no relation, by the way. David and I are not related by blood. We just happen to have the same last name. It's just a common Jewish last name. Yeah, I heard it, and I found it to be remarkable. I guess the circumstances would have to be really perfect to say this is trademark infringement, and therefore we're going to transfer the domain name. But I see the UDRP as a very limited administrative procedure. It's not something where you have all of the files the documents people have exchanged, the documentary, and also the deposition testimony of witnesses. It's not being vetted thoroughly in a real court. And so, I mean, I'm having a hard time with my connection. Hold on one second. I'm going to try and get on Wi-Fi in my office. I'm off Wi-Fi. Can you hear me?
Yep.
Oh, great. I mean, essentially, there's just a lot of things going on in a trademark infringement case that to readily transfer a domain name is really limiting. The policy was created to either transfer domain name or not. It's not to assess damages, like there can be a showing in trademark infringement cases. That's usually a different phase than the actual case itself. Whether or not it is a single judge, that is a decision between the parties. When you're filing your complaint or you're filing an answer, you have a constitutional right to request a jury. You don't have any of that in an administrative proceeding. And that's what a UDRP is. It's not even a true bona fide arbitration. Because in true bona fide arbitration with the American Arbitration Association, or JAMS is the other one, Judicial Arbitration Mediation Service, or any other sort of arbitration, there are documents that are truly being exchanged. There can be depositions, like a court of law, but not a UDRP. UDRP doesn't allow that. We don't even have in-person hearings. So I'm not sure I necessarily agree with Mr. Bernstein, that I'm not related to, with his position. That's pretty much all I can say about it.
Well, Karen, you bring up so many good points there, and I wish there could have been an open conversation yesterday because um, David, I mean, he actually had some. I mean, I know he would have responses to all that. I was thinking, yeah, if it was a different Bernstein on the Atlantic Beach case, would he have ruled the same thing? Because right, he's like, well, and Jeff brought it up. The respondent, the domain owner, they're free to file a lawsuit. And that funny word there is free, right? It's not free to file these lawsuits. Very expensive, and
Yep.
we like it that you not consider it limited because of your skills as a panelist or as an attorney if you're representing either side, but it's supposed to be limited as protection for businesses that have established businesses, and it's for maybe for a court to decide where the infringement is and what the damages need to be, not a panelist, taking the rug out from underneath someone. But go ahead,
Yeah, I
Jeff.
mean, yeah, I was just going to say, and even then, it's not about my skills as a panelist or Karen's skills as a panelist. When you are in a trademark infringement case, you have to show, but through evidence, that the ordinary consumer will likely be confused. And how do you get that? Through the introduction of surveys, through experts that testify. So it's not like this is, Karen or I or David Bernstein could make an assessment. It's not, is it infringing to me? Right? And I don't put myself in the ordinary consumer's mind, but it's up to the testimony and cross-examination and experts and surveys. And it's not like, oh, do I feel more likely than not that it's, that I would be confused, right? That's not the standard. Plus, most of these are in niche industries. So how do I put myself as a panelist in the position of being in the airline industry, right? Or being in the industry of, selling and repairing small planes. I can't do that. Neither could a judge. They need experts to testify. They need surveys. They need of the appropriate people. And that's what infringement's all about. And as was said by Karen and David, the only remedy is the transfer of the name, and that's not the only remedy. Far from it, that a court has, which could assess royalty payments, could, basically say, okay, well, you know, when you use it in this manner, it's infringing, but in these manners, it's not, and so you need to limit your use to the certain areas. UDRP doesn't work that way. It's not intended to work that way. And even in the founding documents of the UDRP, and when we were drafting it, we very specifically did not want to say that it was just infringement, and it was not a mistake. The word's confusingly similar, and I think one of our cases we'll go over today discusses that aspect too.
And I'll get Karen back up here. She probably went to Wi-Fi. Ruben, I appreciate you raising your hand. I saw you. You know I was going to come to you. I'm pretty slick like that, but I don't mind you raising your hand. Welcome. I don't think we've spoken before. You're going to really enjoy talking with me. Ruben, welcome. What's your comment and question?
Well, I very much appreciate that, Counselor. I have some material exposure to this as a layman. I once ran a thing back in, I want to say 2018, 19, and it was an objection campaign to the Equifax class action lawsuit, which claimed that it was going to pay out like $300 per person. We did the math, saw that it was going to be like $6. made a bit of a fuss about it, created a chat bot which created automated objection filings, which both the plaintiffs and defense counsel were less than enthused about. And then, but it was postmarked and so on and so forth. 6 months after this fiasco, right, I get a note saying, "Hey, your website where you had this robot which would allow people to opt out or object to the case, the website's name was No Thanks Equifax, and we've received a notice saying from this company, and that company's called Equifax, and they're saying that your name is confusing people, and that anybody who goes to your website might confuse you for Equifax as opposed to a very reasonably articulated sort of basically a hit piece built into a product to sort of cause a bit of a fuss in the legal system." The question that I have there, and I got another bigger question after that, relatively short, but the question that I have there is, assuming that this is a U.S. domiciled company, Equifax, creating a formal complaint, presumably to the U.S. domiciled jurisdictional powers, if that DNS, if that, I mean, where does the object live? Who is receiving notice from the court system? Or is the U.S. basically being the cops for the internet? Like what? I have no idea what the jurisdictional elements are there as a DNS provider. I presume there's some sort of network internationally.
Jeff, why don't you take this? And Karen, I'm glad you're here too. And then David, I mean, fantastic question, Ruben. Even I know the answer, but we'll have Jeff take it from here.
Yeah, very complex question. Um, so the United States would say that jurisdiction is proper where both the registry is at, the registry of the domain for COM, that's in Virginia, um, and it's proper where the registrar is located, which is wherever that registrar is. If it's GoDaddy, Arizona, Namecheap, I think is California. Not 100% sure of that. Um, so that's where they would say the jurisdiction would be from a court uh, aspect. Um, but that would only be jurisdiction over the domain name itself. If you were suing a person or a company, and not the domain name, like you want damages or the company did something wrong to you, um, then you would sue wherever there's jurisdiction over the company itself. And Equifax, I don't know where they're headquartered, but I'm sure they have a few states in the US that would be, um, they'd be subject to jurisdiction over. But, you know, this was a problem that early on in the mid and late 90s, we all recognized that there was no universal body of law for, say, trademark infringement or to handle bad faith registrations of domain names. And one of the things that ICANN, the Internet Corporation for Assigned Names and Numbers, was um, formed. One of their very first mission was to come up with a dispute resolution process, like an arbitration type process that would handle or could handle the bad faith registration and use of domain names specifically. Um, so yeah, I mean that's kind of where the authority came from. It came from a recognition by initially the Department of Commerce that ICANN was the right entity to do this, and then other countries kind of came along and I'll say voluntarily also agreed that ICANN would be the right jurisdiction or the right entity to come up with these um, policies. And so that's kind of how it started back in 1998.
So OPEC for domains. I'm sorry,
Sorry,
that's a
say that
little.
again.
I said OPEC for domains.
Eh,
That's a
well,
little abstract.
yeah, OPEC would be more the providers of the it was just an organization of providers, right? If it was just registries and registrars, some sort of cartel, but ICANN involves input from the governments, from civil society, from business owners, intellectual property owners, non-commercial users, And the UDRP, when it was created, was a consensus of all of those groups unanimously agreed to this procedure. But yeah, I think some people have said ICANN is akin to a trade association, but you need somewhat, you need some
You do. You
centralization.
really do. It's fascinating to me. I love consensus problems. I don't know if you could figure it out, but I'm a nerd. Um, and international consensus is fascinating. It's why I'm more recently obsessed with a project to create a maritime mesh registry of nautical vessels that contain their own history of record and then interact with the various ports based on jurisdictional requirements, which of course are all over the place for the various ports across the world,
Yeah,
right?
yeah. Ruben, sounds interesting. Hey, you'll notice I'm the one
I
that does the
won't
jokes
derail us
here.
too much.
Hold on, I'm the one that does the jokes here. So just so you know,
Absolutely.
you're new.
My
But
mistake.
Ruben, ask your second question. We have a show to do. It's a pleasure having you here. Are you kidding? Because I don't beat up on the lawyers enough. I love having a guest to do it too. But Ruben, what's your second question? We'll see if David and Karen can tackle that before we move on with our show outline. What's up?
I appreciate the airtime. TLDR, if generative technologies across the board start to increase the rate of copyright infringement, possibly trademark infringement globally in every jurisdiction, what are the likelihoods that the case volume will overwhelm the arbitration processes and weaken copyright in general and weaken trademark in general inside of a 10-year time frame?
Great question. I know David has a remark on that, baby, because of the amount of trademark applications worldwide, especially here in the U.S. and Canada, he'll mention. And then I'd love to hear Karen's thoughts on that too. Go ahead, Dave.
Even if everybody were to employ bots to launch websites that may or may not be infringing, and there's some dispute about that, the whole UDRP process is scalable, and I'm sure AI will help resolve the issues quicker. Um, I'm building a tool called UDRPAI.com, and hopefully we'll be launching soon, and you can just pump in the facts there, upload your documents, and it'll pump out some sort of analysis and do some due diligence work for you. So I think the whole process will be sped up with generative AI.
Did you even understand the question, Karen? If you want to comment, what do you
Yeah,
think?
I'd like you to repeat the question again, please.
Yeah, sure. So some things are easier to enforce than others, right? A bankruptcy is pretty easy to enforce because you only have one single actor and there's a limited amount of people who could file bankruptcy. And so, if triple the amount of people that went bankrupt in a certain year, I'm sure the bankruptcy courts could probably manage it, but it might be tight for a while, right? That being said, if you want to enforce something like jaywalking, well, that's a lot harder because it's harder to observe the infringement, it's harder to assign the infringement, you need to go through due process, et cetera, et cetera. And so I'm just looking from the mechanics of the courts to be able to process disputes and arbitration in general. If we are looking at a class of technologies now that, like, for example, Midjourney or Sora, which can create copyright infringement for sort of images and intellectual property, but also other kinds of property or trademark infringement or name and likeness in California, et cetera, et cetera. In a scenario where these technologies make it effortless to infringe, not like easy to infringe, but effortless to infringe at scale, it makes me wonder whether or not we end up with a jaywalking class of enforcement where there's just so many people doing it that you can catch people, you can find people, and if they make a bunch of money off third-party IP, you can sue them. But functionally, you end up with an unenforceable law. And it makes me wonder whether or not the unenforceability at scale. Oh no, I think we lost her. Did I?
Yeah,
Yeah, my
no,
You
mistake.
and
deserve that,
maybe
Ruben.
that's a
Let Jeff
yeah,
go. I'm sure she'll come
yeah.
back. She's
I can
probably, yeah. Go ahead, Jeff.
try to figure it out. Yeah, look, I think I agree with David that it's scalable. I don't think registries and registrars have the ability, or they have the
Right,
ability,
right.
but I'm not sure that they can handle kind of a bot that came in and registered names one after the other that quickly, but maybe they could. and then you can have bulk action, right? So it's not like each case has to involve only one name. So, if you see 1,000 names out there, then you could put them all in one case. It's but ultimately, at the end of the day, it would be the trademark owner's decision, and it is the trademark owner's decision of which infringements are really worth going after and which ones aren't. If there's just a ton of bots out there that's not really, people aren't really going to those sites and not doing any activities, or it's not really affecting your business, you'll choose to not go after them, just as lawyers are doing that now, brand attorneys with 1,200 TLDs that are out there. They're only registering in the ones that they care about, and they're only enforcing infringements that they see may or are likely damaging them. And so more choices will have to be made on that side as well.
I
Thanks
want to
everybody for the
apologize.
time and attention as well, by the way. Go
No,
ahead, Karen.
no worry. I just want to say that I'm on my laptop now. I think it's a little more stable than my phone. And I think I agree with Jeff's answer on that.
I love that. Hey, all right, we got an outline. Well, we got a main topic today. I'm going to bypass some of the news because it wasn't that interesting anyway. Because we want to get to our topic. We have 3 UDRPs that we're going to review. I wanted to mention right on the chat, I guess, section of this post. If you look at the post for the room here, you can see where David Michaels had posted something that Igor Motsny, friend of the show, had posted on LinkedIn. I think it's valuable to read. I saw Igor here. He usually listens to us from Serbia. We put him to sleep. It's about bedtime for him, so he listens to our show, goes to sleep, of course, and then with this, and so thanks for being here, Igor. I guess we're going to get to this topic of registering someone else's domain name or their personal name in your domain name. I'm assuming that's why GPJR, that's Gary Palmer Jr., is here, because he brought this up in a recent show of his. So before we get to our topic of the day, I wanted to ask you, Gary, did you want to say something before we get going? Are you going to let us go on this? What's up? Welcome to the stage.
Hey, thanks. No, I think this is a really important topic. I don't know how you found out I was talking about it, if you're listening to the show afterward or someone mentioned it, but this is the place to go to learn about domain names and to learn about law. And everyone up here on the stage, and including Todd and Jeff, absolutely, everyone should be following. And I think it's just important to note that what's old is new again. And a lot of what I think we're going to be learning about and discussing in terms of owning someone's domain name, these are questions that we've been questioning and answering for decades. And now it's back in style again. It's retro, if you will, because we have all these Web3 domains. And the Web3 domains are interesting because it doesn't have that clawback mechanism. But even though it doesn't have that clawback mechanism, people still live in jurisdictions and people are still subject to, the laws if people do know who they are. And I want to focus on the people who want to do things right. I want to focus on the people that want to help people and build ethical businesses. And yeah, and we have these worlds merging between Web 2 and Web 3, between ICANN domain names and Web 3 domain names. And I think we need to educate both sides of this discussion, because we have the one side which the domainers are on, and we have domainers that want to purchase other people's names and maybe sell them or maybe throw on fan websites. But we also need to do a better job educating the names of, the people where their names are getting bought, so they know what is legal, what is in the realms of what a domainer can and can't do, and what they can and can't do. Excuse me. Because this has made big news in Web3. I think we all know Thread Guy had his name bought and sold and bought and sold, and that's a what threadguy.eth. So I think I gave a great overview into what I'm thinking about, why I'm excited to be here, and
It was so
all these
so.
edges.
I would say it was great, Gary.
We
Okay,
should tag Thread Guy. Everybody tag
okay,
Thread Guy
but anyway,
or
Thread Guy,
yeah.
that's not a personal name, but we'll talk about, that's his stage name, let's say, because a lot of celebrities have their stage name. So we're getting ready to get to the topic of owning someone's personal name, and I'm going to ask Jeff, David, and Karen. Karen, thanks for being here. I just automatically thanks for spending some time with us today about different issues you may arise when you do. But first, I want to ask name or tips. You came up here. Was there something? It's nice to see you. Was there something you wanted to mention about what we've discussed already that you want to touch on before we get onto our topic of the day?
Yes, thank you very much for having me. Hello to everyone that's in the room. If Jeff and Karen wouldn't mind, for those who are not privy, elaborating on the sunrise and sunset periods that are put in place for trademark holders to reserve their names, and how once those periods pass, those names are available for registration, and how the um, lack of follow-up, I guess I would say, for lack of better words, how does that, what place does that put corporations and trademark holders in responsibility wise when they don't take advantage of the sunrise and sunset periods, and then the names do become available and they can be registered? That would be one thing to touch on. And then the other would be, once we get off into the subject of owning a person's name, if we could go ahead and provide some context around what is a person's name, in a world of billions of people, billions of companies, a rising landscape of entrepreneurs all over the world. Be able to provide a little bit more context so people can understand what it means for it to be somebody's name, because there's millions of people named Dan, there's millions of people named Mark, and so on and so forth. So I think that'll be helpful as well.
Yeah, and we will talk exactly about that many times, just so I can answer it fast. A legal name, if your name's legally Mark Andrews. Okay, if somebody owns markandrews.com and it's MARK, let's say, then you have standing in an ACPA case. Okay, it doesn't mean you have standing in a UDRP, but I'm going to let Jeff and David and Karen talk about that. But first, about this question that he has to you lawyers, the sunrise period, how does that affect if a trademark owner doesn't take advantage of a sunrise period? Does that diminish their rights, or does that affect their rights going forward?
Yeah, so short answer is no, it does not impact their rights one way or the other. So the trademark sunrise period is the first at least 90 days that a registry allows registration. Now, there's some exceptions. There could be these qualified launch periods. Not going to go into that, but essentially, before names become available to the public, it goes through this 90-day sunrise period where only trademark owners can come in and register their names. The trademarks are verified through something called the Trademark Clearinghouse, which brand owners have put their trademarks into prior to the launch of domain of new TLDs. Um, it's a business decision by the trademark brand owner as to which TLDs it wants or it needs to obtain registrations in. Obviously, brands' budgets are not unlimited to register in every single TLD, though I think Amazon and Microsoft and a few others, I believe, initially tried to do that in the 2012 round. But with 1,200 new TLDs, at least now, there's not, I don't believe, one trademark owner that owns their name in every top level domain. And so, no, it doesn't impact their rights. It doesn't lessen their rights. It just means that if a trademark owner doesn't have the registration, and someone then gets that registration, it they have to go through a more expensive process likely than it would have been had they just registered the name in the first place. Um, but it doesn't diminish their rights at all. I don't know if anyone else wants. Karen, you want to weigh in?
I have the opposite, which is the TMCH, the Trademark Clearinghouse. I've used it for clients over the years ago. Uh, all it is a tool in some respects, not just within Sunrise, but the existence of a registered trademark, no matter where you have it in the world, when someone goes to register a domain name, a thing pops up on the screen and says, this name might be subject to someone else's trademark. But it doesn't stop. Let's just say, you don't participate in the Sunrise, but yet your registered marks in the TMCH. It doesn't stop a registrant from registering the domain name. They just get a warning. Now, the trademark holder, if I recall, gets notified. I can't remember. It's been so long. I don't know if Jeff can concur on that, but
Yeah,
there
trademark.
is
Yeah.
right. They get notified, but at the same token, it doesn't stop someone from registering the name. Just kind of warns them.
Yeah, and so you're right that it doesn't stop them. Actually, I created the trademark claims when .biz was first launched. We called it the IP claims, and I should have patented that because damn it, I should have done that. Anyway, it now became the standard in the last round, um, where, as Karen said, you know, if you don't register during the Sunrise, when you go to register, again, this is usually just the first 90 to 180 days after it launches to the general public. So this trademark claims is not a forever thing. So you have the Sunrise period, which allows trademark owners to register domains. Then that's followed by, the trademark claims, where anyone could come in and register a name, but they'll get a warning if there's a trademark owner that has a trademark in the clearinghouse. It doesn't stop them from going forward, but it puts them on notice, which is really how trademark law technically operates, right? The reason I created trademark claims or IP claims for .biz was I never liked the Sunrise. I thought that the Sunrise are automatically giving trademark owners, the first trademark owner that comes in, to give them the name, to me just didn't feel like, um, it was encouraging diversity in the different domain name spaces. And it just didn't, to me, seem consistent with trademark law, because trademark law says, that multiple parties can own a trademark in different classes of goods and services. So why should the same people that have it in .com have it in .biz? That was my thinking. But in trademark law back at the time, you know, back at the time, we got these physical gazettes, trademark gazettes, that would publish, I think it was certainly monthly, if not weekly, would come out
Weekly.
with, yeah, weekly, right?
Every Tuesday. Every Tuesday. It still is. It's
Yeah,
electronic.
right. The physical copy, and people would go through these books of new filings, and they would be put on notice that someone's applied for a mark. And, trademark owner can then choose to file an opposition or not. And so I kind of, when I drafted the trademark claims for .biz, I said, well, that's kind of like what I want to do, which is allow people to apply for names, and then they'll be put on notice, and it's their choice. If they want to go forward, they're going forward knowing that there's a mark out there. Or if they, don't want to continue their application, they could do that as well. Um, that was the whole basis behind the trademark claims.
Jeff,
Uh,
don't they some of the NTLDs, the what we know as GTLDs, the new top level domains, didn't they put a premium on those trademarked during the Sunrise? Or am I imagining things? I'm trying to remember. It's
they were
been
not they were not supposed to put a premium on the names. They could charge a little bit more
yeah, that's what I seem
because,
to recall.
right, because there's some more processing they have to do. Um, but you know, companies like uh, Dot Feedback, that was a TLD that launched, got into a lot of trouble because they said, well, if Amazon wants fire dot feedback, they can only have it if they pay $1 million. But if anybody else wants fire dot feedback, they can pay $20. And so it's basically extorting the trademark owner. That you can't do. And that's what dot feedback tried to do. Um, they didn't get away with that. So yeah.
Okay, we're going to go on to our topic. I wanted the very first sort of scenario I'm going to set up. I wanted David to chime in on first because right now I want to test something. David, come off mute if you can, so you're ready. and I want to test something here, and that is earlier. I said, "Come off mute." What are you, crazy? Come off mute. Sit there for a second, because Jeff earlier said, Todd, I think you mentioned something that David Bernstein was technical, and that was actually David who said that. And then in an earlier room, Arif made the same mistake, confused me and David. And I think it's because David and I are spending so much time together on these Tuesdays that we can finish each other's
Sentences.
yep. See, that's crazy. It's uncanny. Fuck, that joke finally worked. Boy, it was a delay. But anyway, thanks, David.
Could
Okay,
have
so
said
here
the
we.
line from you could have said the line from Frozen and said sandwiches.
It's like you say that to somebody. Of course, I say that to my wife. She thinks that's the funniest joke. I said we're together so often. We love each other. We can finish each other's. And she goes, sentences, like you're an idiot. Okay, so anyway, David, I just wanted you to recognize that I did realize that you said some smart things in a couple different rooms, and people gave me credit. That's why I've done this show. Okay, so now we're getting on to our topic, and David, you could touch on it first. So let me give you two examples. JulieRogers.com is a domain that I own. And I know a friend of the show, and he's really not. He didn't even come on stage at the DNX show, but he was in there last week. Larry Fisher, well known, big timer, big time broker. Okay, he does all these big names, right? He sells the big boys. I think he sold he sold something really big for like 50 million here in the live. Okay, so anyway, AndyWarhol.com is the name that he owns. So David, first to you, when I own a name like JulieRogers.com, and then Larry owns a name like AndyWarhol.com, and for all you listening, if you guys want to see an old website, go to AndyWarhol.com. It hasn't changed it. It basically bought the name and knows you're very limited in what you can do with somebody else's well-known mark like that. So you don't hardly make any moves, like you just keep staring straight ahead. But anyway, so David, first I own JulieRogers.com. He owns a name like AndyWarhol.com. What do we need to be? What rights do we have as the domain owner, and what rights do the people that actually have that name or the estate for Andy Warhol? What rights do they have?
Oh, I wasn't prepared for that technical question,
Well,
but
well,
I'm pretty sure that you can use as a fan site, and whether or not you can monetize in some way is up to debate. There was a case involving Fred Astaire and Ginger Rogers. They were in a movie, and somebody made a movie that was an offshoot of that. It was more recent. He got sued. It went all the way to the Supreme Court. I can't remember the exact result, but I think the point was it was fair use.
Fred and Ginger.
Fred and Ginger, yeah. But if I were to, register Fred Astaire, well, it's kind of old now. Does he still have an estate looking after his name? Where did he die? It depends on which state has personality rights over him. There's no such federal law. It's state by state. New York just expanded it to include post-death. So before, a couple of years ago, it was only up until the point of death, and now it's forever, or at least for a few years afterwards. But it's not automatic. You have to file something with the.
It's 50 years, so it's a pretty long time.
Yeah, but I think Tennessee can go 100 years or something. Is that not correct?
Not familiar with Tennessee. Some of them never end.
Yeah, like California, I think. So it's a hodgepodge of personality rights throughout the U.S. There's no formal law that covers the entire United States. Denmark is trying to do something with people's pictures, and hey, you can copyright your image, and nobody can infringe and make derivative works from it, even if they don't know what you look like. So I don't know how that's going to work out. But anyway, we'll see. It's going to be a big problem with a lot of impersonation and fake videos.
Okay, David, you bring up some good points. So we'll get real specific. We're not going anywhere on this topic. Jason.com just gave me breaking news. Ozzy Osbourne passed away. Saw his big concert a week ago. I've always been an Ozzy fan. I don't want to make light of it. Jamal, was it Warner? I forget his middle name, but young guy, 54 years old, passed. Usually come in threes. If I was a celebrity, be careful out there. But no, Breaking news. Thanks, Jason. All right, back to our topic, and it is important. So when you're owning somebody's name, you are at risk, and I'm going to lead you guys into this. So if you have registered like julierogers.com, Julie Rogers, her legal name, and I was contacted by, funny you mentioned Fred and Ginger, but I was contacted by Roy Rogers and Dale Evans' daughter, Julie Rogers, about the name. She wanted it for, I don't know, in the hundreds. I was wanting only like $4 or $5 at the time. This was almost a decade ago, probably. And I don't even know how I came across that name, but it was so generic that I figured there's got to be thousands of Julie Rogers. And then of all things, she's right here in Simi Valley and contacted me. But the point is, so owning that name, she has a right to file an ACPA action, which is a federal lawsuit, because ACPA says if that's your legal name, you have standing to file a case against that domain owner. Doesn't mean you're going to win. You have to prove several things. And I want to ask you, I guess I'll go to Jeff, and then Karen, I know you've messed with this before, is so in an ACPA action, what would it take for Julie Rogers to win that domain from me? And then if she wanted to file a more simple action like a UDRP, what would she have to prove to have standing, a common law right, if you will, in a personal name?
Yeah, so the main thing, so personal names, as you said, aren't automatically protected under the UDRP, but they can be if, and this is the key, that if it serves as a trademark. In other words, it's used in commerce to identify specific goods or services. Um, if the name's acquired secondary meaning, meaning that the consumer associates the name with a particular source, and that can include evidence. People will submit evidence of media recognition, promotional materials, business use, commercial perception. So the cases are kind of mixed under the UDRP, and we have one that we're going to look at. There was one that was last week as well that we looked at. Um, and so, Madonna, I think, was one of the first UDRP cases. And I believe she lost that one because she didn't show that her name functioned as a trademark. And if you can't establish that your name functions as a trademark, you lose. But Julia Roberts, not Julie Rogers, but Julia Roberts succeeded, I believe, because she argued her name was used in commerce and therefore she had trademark rights. So it's not dependent on your fame. You can be the most famous person in the world, but it's dependent on whether your name has acquired some sort of secondary meaning.
Let me add also that our own Donald J. Trump lost a UDR dispute many, many years ago. And that I think it was right after that he started Trump Steaks. So he would have some brand recognition with his name. Just kind of hysterical. But what about, cybersquatting cases involving personal names? I'm not aware of any. I don't know if anyone's actually brought an ACPA case, that's short for Anti-Cybersquatting Protection Act, involving a personal name. I'd be interested to know that. Does anybody in this group, anyone aware of any
What
ACPA
about
cases?
Pamela Anderson? Does that count with Pamela Anderson when they had a adult website and she fought it vigorously?
Was that an ACPA case?
I don't know.
I think
I
that
don't
was a
Yeah,
even know that.
I'm
California
just
case,
curious because
but I mean,
I've certainly, there's lots and lots of cases in the UDRP context. I just like to know if
Was
there's been
was
any.
there was there oh, what's the name? The, the one who did uh the song Mickey, Tony Basil.
yeah.
Tony Basil brought an ACPA case. Interesting.
Yes, I think it
Well,
was.
Yao Ming
It
brought
was in
one against me.
California.
Yao Ming brought one against me. I'm sure there are some, Karen, but you're good question because most of the ones that I'm aware of, and David brought this up earlier, and he wasn't even ready. But let me take a look at something. It's mostly California has these real, fantastic laws for the right of publicity and persona, protection, and with regards to your likeness, and really because there's a lot of celebrities here, and people try to make money off of their not just their their likeness, but their name and so on. So it is,
Bruce Springsteen tried.
yeah,
Bruce
and
Springsteen
that's a
tried in New York.
UDRP case that we bring up a lot. Thanks, Jeff. I mean, the
That's right.
UDRP, I'm going to get to you guys with your hands raised, don't sweat it, is a Bruce Springsteen filed a UDRP back in 2001 for BruceSpringsteen.com. He lost the case because the respondent, the domain owner, successfully defended themselves by saying it's a website, it's a fan site, and that's how I think Larry's got the AndyWarhol.com site that, no, I'm doing this non-commercial and so on. I will say, yeah, I'm not going to bring up Ice-T. That was a case that was wrong, where Don Osborne transferred Ice-T.com to Ice-T when that was a case where he really shouldn't have had rights to it because it's generic and many people could use the term Ice-T. Bruce Springsteen, on the other hand, very specific. So it was pretty, I'd say, landmark in the UDRP world, at least to me it was, to show, all right, so someone can own someone else's name. Bruce Springsteen doesn't even have his own name. So like you said with Madonna, so that's when we want to say, okay, how can someone own someone else's name? And we're getting to it. I'll get to you in just a second, Gary, because I see 1K
answers here.
pre-punks. Fantastic. I don't know that. Is that your name? Hey, what's going on? You're a parody account. Sounds funny already. What's up? What's your comment or question?
All right, so there is a
Hold on, David. This guy, we were asking,
differential.
letting this person speak, this guest. Let's see what they have to say.
Okay.
Are you talking to me, Todd?
I'm sorry, I'm going to have to bounce. Thanks, everybody. I'll talk to you sometime soon.
Thank you, Karen. We'll talk to you soon.
Thanks for having me.
Yeah, that was 1K. I was getting rid of some of these hands, David, and then we'll try to rush through this. So that was 1K pre-punk. What's up?
Hey, I saw Gary's hand up first, but I just have a quick question. So I heard y'all talking about UAP, these lawsuits and whatnot. What is the stance for, like, let's use like W. Bush as a case study. Like, if I were to not sell the name, but keep the name as like my social media handle, and if I sell domains under that social media handle or that wallet named W. Bush, is that open me up to like liability?
David, and then you can make your comment after that. But
that's what I was going to answer. Okay, so for cases under section 1129 for personal names, if you're just going under the personal name theory, there is no protection for if the domain is not for resale. So if you're not selling the name, you won't lose the name. If it's just a fan site or something else, it's okay generally. Under the trademark theory, if there's a context-dependent analysis, if it's parked with ads, it depends what the ads are. There's limited protection unless sales intended. And then there is, if you're a private individual and like if the name is for sale, like for example, you go to huge domains and you find your name listed for sale there, yeah, you will lose. Like the huge domains will lose it and you can win in court. And definitely the same for celebrities. Is that your experience, Jeff?
Yeah, I mean, like, although I think that in the UDRP, W. Bush has, I don't know if he's got I know he does, if he has a trademark on W, but he certainly has a bunch of trademarks for his, what do you call it? His foundations, right? So he could potentially use the trademark route, not just the personal name route.
And the question too about these subnames, and I'm going to go to you, Gary. The subnames, somebody could get a subname from this, you own wbush.com or with this ETH or whatever, it's a Web3 name. Somebody could infringe using one of the subnames, and that would be still open to, the mark holder saying maybe you didn't do anything, but you sold off that one of these names and that person is infringing in some way. I mean, I'm just thinking, all right, hey, Gary, what comment or question do you have?
Hey, thanks everybody. Yeah, I just want to help better understand this because it's coming into focus, but the picture's still fuzzy. What I've learned is that if you own someone's name, um, there's two different sets of rules. There's one set of rules that's the UDRP, and the UDRP ICANN rules, excuse me, do allow for fan sites and all sorts of things. There's a second set of rules, which are the trademark anti-cyber squatting, rules, laws, whatnot. And so with those, if someone has a trademark on their name, and then I have a fan website, and I do in fact carefully curate the ads. So I'm not sure if we can just pick somebody at random and just say maybe like Grant Cardone. We'll say Grant Cardone has his name trademarked, uses it for business. And if I own grantcardone.com, can I use that as a fan website? And I won't use AdSense. I won't have ads to other real estate stuff. I'll have ads to like flowers and office gifts. Um, can like where are we talking here? Can we dive deeper into this anti-cyber squatting side of things? What we can and
So,
can't do
so,
as owners of names?
so under the UDRP, um, the short answer, but it's fuzzy, right? Is that if it's purely a fan site, there's the concept of fair use that would allow you to have a fan site. That being said, a true fan non-commercial use would not necessarily allow you to make money off of the use of the name, including the selling of ads, whether those ads are related or not related to the person. And so that's where you kind of get into trouble, because if you're making money based on how well known the person is, and that's what's bringing in the ads, then that then could be seen as
I'm sorry,
uh,
excuse me, if I
bad
may
faith.
if I may interject. What if it's a free website, and what if I don't have ads? And what if I have a newsletter and there's no ads in my newsletter, but my newsletter does cost $10 and the website is free? Can I do that?
Well, again, you had me there until you said my newsletter costs $10. Um, that would be kind of in dispute. You know, I can't say yes or no. But if it was purely a non-commercial site and there was no money being derived from that site, then yes, you have a fair use, non-commercial fair use of the name.
I can't make
When
any money though anyway. All right. So let me pivot. If I have grantcardone.com and I make it a fan website about some other Grant Cardone, and it has nothing to do with the guy that has a trademark, and it has to do with like some science teacher in Milwaukee whose name happens to be Grant Cardone, um, then I can have ads on the website or no?
Sure, yeah, I mean, if it's not about the, um, yeah, you can have a
Person that
commercial
has a
site.
trademark.
If it's a real person, absolutely. Um, you know, there's lots of people that share names with famous celebrities, and if you want a website for that other person, it's dedicated to that other person. You could do whatever the hell you want with it,
Okay.
with that other person.
New question. What if I'm working with this artist, really good artist? Nobody knows them, but they have some previous work and they're a good artist. And we make a new character called Grant Cardone, who's a dolphin trainer on the moon of Europa. And it has nothing to do with any likenesses, are purely coincidental. Can we create a new comic book called grantcardone.com that has nothing to do with the someone that may have a trademark?
David, you want to do that one? I don't want to hog this whole thing.
I don't have an answer for that. That's That requires some deep analysis. Can't answer that on the fly.
Well,
Yeah, it
yeah,
may not be it may not be a trademark claim, but could be a right of publicity claim. The safest example is if there's a real person, um, that then obviously you can do anything about that. If there's a real person that shares a name with a celebrity, if you want to create a character that shares the name with someone else, if they're a celebrity, then it's all about whether um, the the famous person thinks you're trying to tarnish them. So let's say you created a Julia Roberts character, and she's got long hair, but she looks disgusting and um, just does things that the real actor Julia Roberts doesn't do. They could kind of claim tarnishment, but the short answer is you could create character names like in books or in um, that may by coincidence have the same name as someone else. But if you're trying to use their goodwill to sell your books or to sell anything, that's where you run into a problem.
and
Okay. So
Gary, hold
that
on,
creates
Gary. Let me
that
say
creates a
something.
lot of, well, can I just ask one more question? Oh
Well,
yeah, just
yeah,
jump in,
you
Chad.
can
I'm
ask
sorry.
one more, but let me answer because I mean, I know, you want to be clear and you want it to be not fuzzy, but the truth of the matter is, like what you were talking about, ACPA actions, so a federal lawsuit, right? We're just saying Grant Cardone would have the right to go after you. Now you're going to have tons of defenses. Okay, your defenses are going to be, I'm a news site, I'm legitimate news, and I have ads on my site to pay for the reporting that we do. And then he's going to be able to argue, well, you're also defaming me a little bit in some of your opinion pieces, so we believe that there's other things that can come into play. So basically there's no right or wrong answer. Yes, you can do that. No, you can't do it, because you can have a commercial site with somebody else's name, but the it's going to be I mean, really, like David was mentioning, there's too many details. It's going to really need to be analyzed, and we're going to need to know you're getting your traffic. How are you buying traffic to, or is it coming? Um, how is the traffic coming to the website? But I mean, they're going to look at just so many different aspects. We're just trying to say that if you own someone's name, they're going to have standing. And now we're leaving the UDRP out of it. This is court cases. If you own someone's name, or even something close to their name, like I owned YAO11, Yao 11 in a domain name, Yao Ming had standing. The courts agreed he had standing to even sue me for that. But certainly, if you can show the court my legal name is John Smith, this guy owns johnsmith.com, you're going to have standing to file an ACPA action. But you know, they're certainly going to have a lot of defenses owning John Smith, like you mentioned, so many other people with that name. But you're gonna, it's not here's how I'll sum it up. The ACPA action makes it simple for you to have standing if you can show that's your legal name, but yet it's very difficult to win, and I say win an ACPA action if it's non-commercial, like Jeff says, or if it's commercial and you can show that you're not doing some of those other things,
Right.
like
And every movie and a lot of books, I couldn't say every book, ends with at the very end, this is a work of fiction. Any resemblance to actual persons, living or dead, is purely coincidental, or something like that. You'll always see that disclaimer. And that's what people do in books and movies to kind of avoid, because anything you name your character is probably going to be the name of a real person somewhere. Um, so that's there are things you need to do if you know that a real person has that name, and you're writing a fictional book, a comic book, whatever it is. You need to kind of make sure that you're doing things that people will not associate um, your character with the person in real life.
I think we're saying here that you can own somebody else's name. In some cases, if they're super famous, then you're even more limited, I would say. But anyway, let's go to Namer Tips, then Ragu. We'll try to keep going on. Then Gary, you can follow up with your question. We'll try to get to our cases, but let's get through this, guys. Namer Tips, what do you have?
Okay, so again, this is a great conversation, but there's a couple of things that I think that we should definitely point out, and one is the U.S. in particular being a first to file territory, right, when it comes to IP related things, and how that serves as a gateway for monopolization, if you will, right? And so when things get to that point, that's when you tend to see the courts and enforcements, and even from the court standpoint, things have to be proven beyond a reasonable doubt, right? When Gary was referencing, things being fuzzy, I agree because a lot of what we're talking about is functioning within the context of corporatization, trademark law, and all of those things. And we're talking about people's names, which kind of lends itself to personal identity in one way or another, right? And the reason that this is a bit of a concern is because if there's not a stronghold that's gotten on these things, we can be going down the path of people petitioning to own language and words, right? And that can be very dangerous. So I think one way that you stay away from that is by leaning into whatever mechanisms that aid in a clearer context being brought forth in these instances, leaning into those types of things. And I'll give you an example: the TLD extension. So the language is very important here because we're talking about people's names. And I think that's where it gets a little bit tricky, because if I was born Dan Martin and somebody else was born Dan Martin, I personally, this is solely from a personal standpoint, I feel that we both, have right to the name. We both own it, right? But we understand that the world doesn't work that way. However, I think that when you start to get into the digital space, .com is often promoted as the king of extensions, right? We're not in that debate. But .com is literally short for commercial. So I can understand someone deciding that they want to go ahead and go after someone if they're using a name that has an extension that is contextualized to represent commercialism, and they're using it in a commercial fashion, and this person has a trademark that protects the name commercially. It makes all the sense in the world. But if you have a grandmother and her name is Mary Jones and she makes great cookies, and there's a .cookies extension, and she registers Mary Jones .cookies, somewhere else there's somebody else who has Mary Jones and they're doing something totally unrelated to cookies. But because they're on this path to try to collect as much digital space as they can, they say, you know what, we want that name too, regardless of whether we're in cookies or not. It's not fair for that grandmother who's not using her site in relation to anything this person has going on to have the name stripped from her. This is why I think decentralized names are really going to pick up steam, because for every TLD that's not an ICANN TLD, the decentralized side is going to be able to support that. So
No,
I
hold
say all of
on,
that.
Chris. Hold on. No one's going to take away. First of all, that's your best defense. When your name's Mary Jones, you said Dan Martin. Dan Martin, Sue and Dan Martin. Yeah, the biggest defense Dan Martin's going to have, the respondent in the UDRP or the defendant in the case, he's going to say, my name's Dan Martin. That's one of your best defenses. So no one's going to take away maryjones.cookies because we're maryjones.com doing it. We sell aircraft. So the thing is, bottom line is she's got the best defense. Shouldn't be taken away. Now we know there's crazy exceptions. If she was using their logo and she was actually selling aircrafts at the cookies site, and she called them and said, "I want $1 million for my name. I live across the street from you," and she's throwing eggs at their cars every day. There's a way she could possibly lose the name, but very hard
Definitely,
to understand. But yeah. So anyway, so
definitely.
those examples of neighbor tips for Dan Martin. Dan Martin, his great defense would be, I'm also named Dan Martin. So you do have a defense if you have a similar name. That's what we were absolutely trying to say. We'll continue on here. I want to get to
You're,
Ragu.
you're spot on.
Yeah.
I'll land it here, and thank you for allowing me to speak. I'll just land it here. I'm not everything that everyone is stating here is completely accurate. I guess maybe what I'm referencing is that there are people who don't move ethically, and they do want to take everything that's available or even looks similar. And that's kind of what I was looking at. But you're spot on when you reference that in theory, if we're doing things the right way, the ethical way, and the laws and the systems are not outdated, and they not only take into account the corporate channels, but also the everyday user channels. If we're working within that capacity, then everything makes all of the sense in the world. But as long as we have people that are greedy and they can lobby to define what a fan site is and things of that nature, then I think that we'll always be fishing through this terrain to figure out what is the common medium that we can reach to make sure that everybody is accommodated.
Yeah, and in Web3, you own someone's personal name, and I'll go off personal names real fast to say you own Gucci.eth. So that's an obvious trademark. Same thing goes. What they're going to have to do is they can't use a UDRP because .eth doesn't fall under those guidelines. So they could certainly file if it wasn't an ACPA case, it would be one of these state cases that we talked about, or it would be a federal trademark infringement lawsuit under the Lanham Act saying, hey, they're infringing on our mark. And then you would have to do the normal thing and find who's infringing, how are you going to serve them, and so on. But Ragu, what's going on? Nice to see you. What question or comment do you have?
Hey, hello, Ted, Jeff, David, and everybody else. I have a case going on in the courts in India, but regardless of that, the one point I was thinking about it, popular movie actor, yes, 25 years ago registered it in the domain name because he was a good actor. He is a good actor. And suddenly, that time, he, he declared bankruptcy, means personal bankruptcy or the corporation bankruptcy. And during that period of time, which he declared bankruptcy, I remember during that time, I registered a domain name. As a fan, you can say that. So now, after 25 years, the case goes to the court and he's claiming that name. And then he probably rise up back again in the industry or become popular again. So where is my argument if I come up with this argument saying, while I took this domain name, two reasons, because of the fan, and top of that, declare bankruptcy by personal bankruptcy of this person. And waking up after 25 years and realizing it, oh, I should have done that. And now he is again a popular identity. What would you have argument if you want to say that in the courts?
Go ahead, guys. I have all sorts of bullshit to say, but what do you think, David? How would you defend that?
I don't know. So, I don't know how Indian law will analyze this, but if it was under the U.S. PTO, sorry, under ACPA, if the site's listed for sale at the time of registration or right soon afterwards, then you have a problem. But if you didn't put it for sale for 20 years and now you put it for sale, well, I think that you might be safe on that part under 1129. But in India, I have no idea. And ACPA doesn't really apply to your case at all because you're not in the United States and the plaintiff's not in the United States. So who knows?
Jeff, anything? I mean, I have an idea.
Yeah, I'd have to also look at so in .in,
No,
I'm
no, no.
not sure.
We're not talking about .in. We're talking about .com.
Okay, good. That's better because I didn't know IN's dispute whether they adhere to the UDRP, but the bankruptcy doesn't affect the rights in the personal name. Just because they're bankrupt doesn't mean they lose any rights. If they've continued to, if they have trademark rights and they continue to use it, they didn't lose their rights simply because they declared bankruptcy. Um, it's going to turn. It's hard to answer the question because it's going to turn on evidence. What does the evidence show? Has the name been for sale all this time, or the name is just now for sale? What is it for sale for? Is it extremely high amount? That's dependent on, where it could only be really be sold to one person. Um, you could say now that you intended to use it for a fan site, but do you have any evidence to back that up? right? That's what the courts are going to look for. And
Not
but
only that, I offered few times directly to the person if you want to have it for free, and simply denied, not interested. That evidence I have. Approached, and I say you can have it, just because of good gesture of I'm your fan, and if you can do better than that, me, why not? But I'll be doing the same thing. What you would do it for yourself, promote you. So in that case too, as well, denied twice or thrice by offering him for no cost, and suddenly, because the case is not only about the domain name, case is about the whole persona about the person, pictures, clips, style, and like a duplicates performing on the stage. So it is not targeted to me, that case, but I came across just because I own the domain name. So okay, involve him as well. So the case is not purely for me or targeting to me. It is another 10 reasons he wants to protect his identity or the style or persona about the person, for legacy after he even passed away. The person is now 80 plus years old, and he's just trying to protect his rights even after he passed away. Movie rights or acting rights or the style rights or even dialogues rights. Um, so it is not just a case about domain, but I happens to be involved because one of the scenario is .com.
Well, I mean, so you're telling us all the reasons why his estate, or him now, but his estate eventually will want the name. So we know all that, Ragu, about the defense. Jeff mentioned it. So you can say, listen, I guess if you want to, well, you don't bring up the bankruptcy stuff because it doesn't matter. And you'll find a lot of people that own domain names throw a bunch of shit at the wall when someone comes after them and they say, I registered it because I'm a fan. Also, he filed bankruptcy and that. Well, what is it? So, that's why you be careful when you don't answer back. You have to answer a court case. You don't answer back a UDRP. Usually it's held against you. They'll believe everything the complainant says. But when you answer back, you want to be specific, especially truthful. And hopefully that helps your case. I'm a fan. Okay, I got it as a fan, and I was setting up a fan site, and here's all the stuff I did to set up a fan site. If you said you're just a fan, I never did take any action to set up a fan site. All right, that's not as strong. At least you're being honest there, because you don't want to bullshit and say, I'm a fan, I'm setting up this non-commercial fan site. All right, well, what did you do? Give us some evidence to show that you reached out to a designer and said, hey, I'm setting up this fan site, I love this person, I want this to be non-commercial, I've offered. And then you can even bring up, I guess, in part of your defense, hey, I did offer it to the person themselves and said I'd give it to them free. Otherwise, it'd be nice in the email when you offered, hey, I want you to have this. If you don't want it, I would simply, I'm a fan, I'm going to make sure I would never, do anything commercial, but I want to, stay well within my rights. But if you don't have it, I'm going to keep it as a fan. And, like I said, you're got to be real careful in anything that you say or how you would answer in a lawsuit, because it could be held against you right then. Except as a fan, you do have a right to it, but they want to know, are you really a fan? And we have some friends that own some famous celebrity names that I know. They're very limited in what they can do with them. But yes, you do have a right to them, but it's best if you have in action a website that is non-commercial, that is showing that exactly your defense. I'm a fan. This is non-commercial. You have disclaimers on it saying I'm not related to this person. I'm just his number one fan. I think I might still own oprahfan.com, hoping to sell it right to her. Why would she buy that one? I don't know if I still have. I probably dropped it. But the point is, so fan sites you can have, but it is important to really go that step and show. We're going to get to our cases real fast just so we can get through them. This is about 95 minutes. Okay, so this is not a topic we're going to not touch on again. Okay, 1K. I'm going to give you one last. We got to get to our cases. We're over time, but you got your hand up. What did you want to say or comment before we move on?
Thank you. I just wanted to clarify. Okay. So I have wbush.eth. It's parody on George Bush, but I'm not making any money off of the Twitter. I don't have a website. Uh, but if I were to sell some of my ENS names, would that be profiting off of George W. Bush? Even though, let's say my wallet isn't named W. Bush, or it could be vice versa, either way. But if I sold anything under that wallet, would I be liable? And then also, uh, one more thing. Yeah, I guess you could just
You
answer
can't
that now.
remember that. Okay, so let me answer real fast. Say if you have a parody of a person and you're selling merchandise, and you can do that. Now, you must be show that it's a parody. This is a character that you've created. It's a parody of someone, and people are into that parody, and that's why they're buying it. But definitely, as soon as you jump the thing to be commercial, the floodgates, I say, open on their behalf, on the complainant's behalf or on a plaintiff's behalf, to say they're making money. I'm telling you, especially like in California, if you're making money, how are you making it? You're making it off their likeness. Even, you better be clear, even if it's a parody, but off of their reputation. In some jurisdictions, basically states is what I'm saying here in the US, are give these plaintiffs, give these famous people a lot more rights than other states. So yeah, in California, they'll run you through the ringer. We know you're trying to be funny. We know you have First Amendment rights, except if you're trying to make money off someone's fucking reputation, their goodwill. But if you're making money, you're really going to run up against a lot of. You're going to have strong attorneys to protect you. If it's non-commercial, that's when the courts will, or definitely you have a lot more favor from the courts when you're not making any money off of it. But anyway, I guess Jeff had to leave. What's up, David? Should we finish these cases
I
or
got no
just do them
comment on
next
that.
week?
I think we should leave them for next week.
Okay, then we'll stay
We
open
can
for one
leave,
more
yeah.
minute here.
But
Okay,
you know
our
what? We can
cases.
actually just do the Jekyll Knight case. Why don't we do that one? Because that's on topic about the person's name.
Okay, which case? The can case? Which one? Oh, the
Jekyll
one that
Knight.
was just the news article. Yeah, go ahead. This was the
Yeah.
domain was JAQUEL Knight, so it was a personal name. Jekyll Knight is a famous choreographer, and his company is JK Creatives. We weren't going to review this case, but tell us, David, about this case and why it didn't turn out in favor of the person, Jekyll Knight.
Yeah. So this guy is 35 years old. I never heard of him, but he's a choreographer and he has a company with his name in it. And he dropped his domain name. And then somebody in Turkey decided, hey, I want that name because it's got some juice in it. And then he put some ads on it. Then he redirected it to a gambling site. And that was a total shocker. But I think there's an allegation in the complaint that the guy in Turkey actually copied the content that was on Jekyll's website before and then just like put it all up there to make it look like the same site, but then monetized it for a while. So that was a interesting situation, and he couldn't prove his trademark rights in his name because he didn't have a trademark on his name, and the case was dismissed. That was a UDRP. And as far as the ACPA goes, well, he probably Jekyll might win on ACPA at this point, but can't say for sure. Definitely the gambling really hurts.
Well, we appreciate everybody being here. What a fun time. And you can see, um, I know Gary wanted, people want specifics. And the truth of the matter is, you can own a celebrity name, and we'll get back to just the UDRP. You could lose it real easy, or you might be able to keep it. In that Jekyll Knight case, basically in that case, they said, well, your company's JK Creations. You might be famous in the circles you run in, but this person, you accidentally dropped the name, I believe it was, and that this person picked it up, and that's what happened. Their management company dropped the name. This person picked it up, and I believe in an ACPA case they would have a better chance. It's much more expensive, but in the UDRP case, the panelists just said, you haven't shown, you don't have a trademark to your name. Your trademark, your business is JK Creations. That's what people hire you at, pay you at. So I'm going to say you didn't even pass the first prong of this. That's what the panelists said. And that's why I said, so you're not going to be successful at this UDRP action, and the name stayed with the domain owner. But that domain owner, shouldn't be, patting himself on the back, because he probably did. Why did, I don't even know the whole, why did they register that name? Were they really targeting? It was a Turkish person that picked it up, but I believe, like I said, I believe there may have been some targeting. And I didn't look at this case specifically, but because the complainant just didn't prove the first part, that he had a common law trademark on Jekyll Knight, it was dismissed. Next week, we're going to talk about 3 cases: CANNES.ai, can.ai. I'll get you excited about it. Yeah, they lost that. This guy owned this geo domain name in the .ai and lost it to the city in France. And then we're also going to talk about Sequent, SEQUENT.com, that friend of the show, Zach Muskovich, he represented James Booth, also friend of the show, who was the domain owner in that case. And we'll tell you how that came out. And then voices.ai. Okay, voices.com was the complainant in that case, and they owned voices.ai. Let that drop accidentally, and it was picked up by a domain investor, and John Berryhill represented that domain investor out of Ukraine, and we'll tell you how that case went. But absolutely, you're seeing there with voices.ai, descriptive name, but someone can still file a UDRP. And I will tell you a little bit about it, that yes, they did have standing. I mean, meaning the case did go forward. The panelist, 3 members, said, yeah, they do have a trademark on voices, so we're going to let this case proceed, and then we'll talk about how it turned out. So even descriptive domain names can be, you could still be on the receiving end of a UDRP. Finally, that one last hand raise we're going to go to, since we have room for our cases next week. 1K pre-punk, what's up?
I didn't even know I had my hand raised,
Fantastic.
but since you're on me,
Yeah.
I actually had a couple follow-up questions. Okay, so what I'm gathering is a social media is fine, a website is fine as long as it's not commercialized. But now that you're getting into crypto, the waters get a little more murky. If I were to sell, like, let's say, T-shirts with W. Bush's name and likeness, that opens me up to that makes me susceptible to liability. One more thing. Oh yeah, do presidents and like politicians have more or less, uh, like less rights with their IP than, like, let's say, like a Hollywood actor, or is it the same?
David, and I would say less, because you do have some First Amendment rights, and we're talking about, as we're crossing over in other laws, but rights to messing with politicians. When you, like I said, when you're making money off of them, well, when you said non-commercial, you're not always safe non-commercial, because you could still be defaming someone, you could still be uh, detracting from, maybe their site. And even if you're not commercial, it doesn't necessarily mean you're in the clear, but it certainly is a big step in the right direction. David, what do you say about politicians owning a politician's name? Do you have more leeway since they're in politics?
Yeah, for the commentary site, you got more leeway. You can't actually register their name as a trademark without their permission. Like anybody tries to register the word Trump or a trademark including the word Trump gets flagged for saying, hey, do you have a letter of consent from Donald Trump? Because when everybody says the word Trump, everybody believes it's like Donald Trump, the president. So not even his son. But if you have his name like TrumpNews.com, you probably have a lot of leeway. If you have TrumpEpstein.com, well, that's newsworthy too. So we'll see, but can't say what would happen.
Well, with the advent of subdomains, couldn't you like argue that having Trump, the parent name Trump, is like good faith, that you're gonna issue a subdomain like news.trump.eth? and then but you just haven't done it yet, maybe. But would you also recommend, like, if you have a politician's name or a celebrity's name, that you reach out to them and try to give it to them? Because I've tried to give company names, some of their names, and they didn't want it, but that was years ago.
Yeah,
But
I was on mute saying fuck no, but they could hear me on uh, whatever YouTube because I fucking have to mute both things. But anyway, no, reaching out it really just causes problems. But I know you can't stop people from doing it. I have friends reach out to actors. Hey, I want to have lunch with you. The actor's thinking, fuck you for taking my name. I don't care if it's 20 years ago. Well, I can't believe Namer Tips would be brazen enough to raise his hand when I'm trying to close. I'm going to go to him anyway. So let's do it. It's our last question or comment, and I'm going to wrap this thing up like you can't believe. All right. So what's up? Namer Tips, hit it.
Yeah, I just had to, Todd. I just had to. Thank you for this space. I know you're going to wrap up. I'll keep it short. I know that 1K was talking about, as I was listening, that specific I have your name. I think that that's a really major point of contention. Um, and I think sometimes when we have a name and we say that, sometimes it can be like, a knee-jerk statement because we know somebody else with that name. And then sometimes it can be, intentional. So what I'm getting ready to say now doesn't apply if, one is intentionally getting someone's name. In other instances where you might get a name and someone might, that might be a name someone uses or whatever. One thing to keep in mind is the IP that's attached to the name, right? If you wrote, I think someone was using the comic book example earlier. It might have been you. You create a comic book, it's your IP, you attach it to a domain name, you add a disclaimer. It doesn't mean that someone won't reach out and attempt to take action. They say you miss 100% of the shots you don't take. And a lot of people who are familiar with the law and any type of business, they operate with that philosophy all day, every day. But it's important to know that if you have no malicious intent, cross your T's, dot your I's from the very beginning, make sure that you are prepared for someone to knock on your door, whether or not you were intending to do anything malicious or not, and make sure that you have your details in order just in case you do have to go ahead and visit a courtroom and make a case for yourself. And even if you check all those boxes, it doesn't mean that you're going to win, because we still have a court system where, and this is with all due respect, where a lot of unless you're, you're going to court in like Delaware or some place that's, their courts are built to accommodate, these very intricate situations. You have to understand that, the court system and the laws have to catch up, right? So you're kind of like out there by yourself and you're playing a really give or take game. So you have to ask if whatever it is that you're doing is worth the inherent risk that you're taking on. You use the the W. Bush name that you were referencing. You said, I have his name. It's an ETH name. That might be tricky territory. If it's your aim is his name, I want to get it to him, or I want to use it, I want to sell merchandise. Yes, that's a point of contention, and that could bring forth problems. But if you had some other name and say it was on ENS, take into account that everything that you do with that name, like those cards that people put in the marketplaces and it has the name on there and then it has whatever image in the background, yeah, you're going to open up some problems for yourself if you have that person's name and you have their picture as the description card and you sell it and in the description you're saying that it's this person's name. That's just asking for trouble. But if you're not doing any of that, it does mean you won't have an issue, but you'll have less of an issue if you have other supporting things that you are doing and you're saying, hey, this is something that I'm doing that's unique to this situation. I understand that this person has had their name for some time and they've been using it in this capacity. I respect trademarks and all of this, but this is 2025 and beyond. And listen, I'm one of the billions of people who has a brand new idea and it just happens to have this name attached to it. That is not legal advice. That's just a disclaimer for the people who are being creative. Don't lock yourself into a room thinking that just because somebody owns ABC, you can't use ABC. Todd, that was a joke.
Yeah.
But no, I appreciate you all. You all have been wonderful.
Hey, thanks for being here. I'm going to sum up, and I know 1K will like this. Okay, if you own Jason, like Jason.com does, he can contact everybody on LinkedIn and say, hey, all you Jasons, I have this name. It's fantastic. I think a lot of you could benefit from it. Even if he owned jasonsmith.com, he could reach out to a bunch of Jason Smiths and say, hey, I know it can be sensitive. You think somebody owning your name in a .com, but there happens to be 2,000 of us or 2,000 of you if your name's not Jason, and I'm reaching out to all of you because I believe owning your name can be hugely valuable. And then about 1K, when you're talking about, the two different things that would get you in trouble, if I was the lawyer on the other side, I would say, so now you're reaching out to him saying you wanted to give it to him. Well, I thought you registered this thing as to make a parody of it. And the thing is, how they come at you on the plaintiff side is, so you're not the guy that created Family Guy. You haven't done a bunch of parodies like the Beavis and Butthead people or King of the Hill. So this was your first one you were going to create a parody? Oh, you can, but we need to know, like I said, what actions have you taken? And truly, so now you have you can't, because you can't just go, I know that's one of my legal ways, my legal defenses. You need to show what you were doing to really make this into some type of parody, because it's, questionable already. And then, like you said, reaching out. So you had all sorts of things on the table, huh? Possibly doing this and then selling off sub names and news sites and all sorts of, and somebody would just think, so, but you were never going to do a parody account. It is true that you have rights to do something like that, but that's why many times when you register a name, whether in Web 2 or Web 3, your best bet is to really make no moves with it at the start. And any move you do make sure it's in the right direction, meaning things that you legally can do. And they'll hold it against you reaching out to any mark holder. And especially when it's a personal name, because it's not like you could I reached out to a lot of W. Bushes. All right, that's going to be it for today. David, I'm going to give you a chance if there's anything you want to say. Just thanks for sticking it out with me today. Jeff had to jump off the boat and swim back to shore. What's last comment
Just
from
be
you?
posting stuff on domainlawpodcast.com, and welcome to take a look at the website weekly and subscribe if you like. I'm going to put up a subscription link later today.
Fantastic. Domain Law Podcast. And, our show, we just have an outline. I'm going to bring up our site again. But everybody, thanks for being here on Thursday. Josh and I are doing a show on domain investing. It's just solely on domain investing. And we have a gamut of topics there. That's on Thursday, 10 a.m. Pacific, 1 p.m. Eastern. I hope I see you there. And then, of course, next week right here on the Domain Name Law Show, every Tuesday. We're at 5 years now. All right, that's it for today. Have a great rest of your afternoon, wherever you're at.